Good morning. Thank you for the opportunity to address the Planning Committee today. I am Diane Reid, a Director of Kingsford Stadium Limited, but speaking today in my personal capacity. It is my intention to highlight what I understand are the considerable issues of law which are relevant to this application, to make the elected members aware that the application before them, which is contrary to planning and transportation policy, is also contrary to the law and vulnerable to challenge should it be approved. The application before the Council must be resolved in accordance to the law. The Local Development Plan, adopted in 2017, is very current and relevant to this application. Case law has established that interpretation of planning law is not a matter which a planning authority is entitled to determine from time to time as it pleases. The Council must consistently implement its policies regarding the determination of this application. One application for land adjacent to the site for a golf driving range has already been refused, and councillors will be aware of the recommendation of refusal for the Prime 4 change of use. The Council must refuse this application to be consistent in how it applies policy. Legal guidance provided by Ailsa M. Wilson QC suggests that there are not only issues of planning judgment to be addressed, there are also questions of law. The first is that the sequential test must be applied. There are allocated sites within the LDP at Lauriston and Kings Links, and the applicants have not presented sufficient evidence to discount use of either of these sites. The 8.3 hectares of land available at Lauriston is more than adequate to deliver a stadium, as shown in this table of football stadia and their land use. It's simply the applicant's inflexibility and fixation on co-location of facilities which is preventing adoption of this site. The Kings Link site, identified within the current strategic plan, continues to be a sequentially preferable site and in keeping with the city centre master plan. The applicants have presented a letter from Craig Group indicating they do not wish to sell the lease. This situation was understood as part of the 2003 North Beach Planning Study and the Aberdeen Community Arena Full Business Case of 2008, prepared by the Council. Both stated that this leasehold was not a barrier to development of the site at Kings Links. The Strategic Development Planning Authority also indicated that the matters of land use for the Kings Links site could be addressed to make the site available. It is very significant that there is a recently adopted LDP which reflects the approach in the Strategic Development Plan to the spatial planning framework for Aberdeen. Development plan policy is just not one of the many material considerations to be put into the mix when considering the sequential approach. The determination of this application should be first and foremost be governed by the development plan. The Kingsford site therefore fails the sequential test, as there are other and potentially available sites allocated within the development plan on which development could proceed in a reasonable time frame. The second matter of law relates to the perversity and the unreasonable nature of the proposed development. There is no legal requirement per se to disaggregate the development. However, it is not purely a question of planning judgment, but one must consider whether the applicants have correctly considered policy. The applicant's requirement for a 25-hectare site, when compared to the land use of other successful clubs across Europe, is unreasonable and therefore susceptible to legal challenge. Equally, the out-of-town location, the failure to conform to planning or transport policy, and the poor economic and public benefit case are all grounds on which this application can be challenged. Emails between officers of the Council obtained by Freedom of Information request state the following opinions of the applicant's proposals, and I quote, "The scale, type and form of development now proposed is way beyond which we are likely to be in a position to reasonably support and would have a particularly high and negative impact on the remaining greenbelt which frames Aberdeen. Even promoting the scheme through the next local plan, which is some 5 years or so away, is unlikely to pass through the scrutiny process. It is clear that officers are fully aware of the key issues in this application and the need to recommend refusal. I urge the councillors, do not be swayed by emotive words like pride and feel-good factor. This is about planning. I urge councillors to defend the Greenbelt and the intentions of the 2017 LDP and to refuse this application."